Good afternoon, everybody. It is a very difficult kind of situation outside because of the coronavirus. My humble request to all of you is that please stay home. Please try to understand that this is a time when we need to be home so that we can protect ourselves and we can protect others also. So, the best action and the best protection against this situation of COVID coronavirus is that we should remain home. We should protect ourselves and we should protect the whole of the society. That is what is an endeavor, even from the government and even from all of us. We must take this pledge that we will remain in home. In this context, let's study from home. And that is why I've decided today to discuss a very important small lecture with you on a topic, right to life and personal liberty, which is embedded within Article 21 of the Constitution of India. Now, when you try and understand this particular domain of Article 21, it says that no person shall be deprived of his right to life and personal liberty except procedure established by law. Now, that liberty, the term liberty, life, liberty, and procedure established by law, this is what is a matter of interpretation because it is written in the Constitution. But time and again, it was challenged that what do you mean by the term life, liberty, and procedure established by law? In this context, when Article 21 was embedded within the Constitution of India, and when very first time in 1950 it was challenged before the Supreme Court in A.K. Gopalan versus State of Madras, the point of contention was what kind of procedure we should have. It is a matter of preventive detention. Supreme Court held that procedure established by law means the British concept of liberty. The Supreme Court has taken a narrow view in this particular judgment. It says it is a British concept of liberty and it has nothing to do with the American due process clause. The decision to some extent was narrow but opened up Pandora box. And in 1978, when the passport of Srimati Maneka Gandhi was impounded, she challenged the validity before the Supreme Court. And a landmark case of Maneka Gandhi versus Union of India came into being in 1978. The Supreme Court expounded the Golden Triangle, Justice Bhagwati and Justice V.R. Krishna Iyer. Supreme Court held that without freedom, there can't be liberty. And without liberty, there can't be equality. So there is a connection of freedom, liberty, and equality. And when three of them combines, it makes a procedure that is just, fair, and reasonable. Whenever there is arbitrary action, then the rule of law must proceed, and that rule of law must be just, fair, and reasonable. When the Supreme Court says so, the Pandora box was opened. It was 1978. In 1981, in Francis Corelli, again, it was challenged before the Supreme Court. Now, what is the meaning of Article 21 of the Constitution of India? The Supreme Court again held that the procedure must be reasonable, the procedure must be just, the procedure must always be fair. In 1985, again, in Olga Tellis versus Bombay Municipal Corporation, again the Supreme Court held that any procedure that would deprive a person from fundamental right should conform to the norms of fair play and justice. Unless and until you have an accountable and unless and until you have a transparent system, you can never provide justice to the people of India. Access to justice is prerequisite to administration of justice. So that is something which is very, very important. And that is why, the Supreme Court again upheld the corollary of Article 21 in the light of Maneka Gandhi case. Then in Unni Krishnan in 1993, the Supreme Court expanded the horizon of Article 21 in the sense that it includes right to privacy, right to go abroad, right to shelter, right against solitary confinement, right to social justice, right against handcuffing, right against custodial death, right against delayed executions, doctoral assistance, right against public hanging, right against protection of cultural heritage, right of every child to a full development, right to education, and protection of under trials. So these are the dimensions which were all, read within the lines of Article 21 of the Constitution of India by the Honorable Supreme Court in Undi Krishnan, and so on. So the development took a very, very interesting turn, when there was a debate, on a concept of Article 21, which talks about right to life and right to die. And the substantial question of law was whether right to die is a fundamental right enshrined under Article 21 of the Constitution of India. Now, this is something which is very, very important for the purpose of understanding law. Now, in this context, there is a very interesting kind of an analogy. But first of all, you will have to understand one important criteria, that there is one provision, and the provision was Section 309 of the IPC, which declare committing suicide as an offence. Now, when 309 is an offence, how come right to die be given under as a fundamental right under Article 21? It is not possible. But there are developments, and the developments were that there were a number of people who are on deathbed from last 20 years, 25 years in vegetative state, and there are a number of medical conditions by the virtue of which they are in coma, and from 27 years. Aruna Schonbach case is one of the best examples in this regard, and that is why there was a debate regarding the passive euthanasia or the active euthanasia, and in that context, Bombay High Court gave a very new kind of a judgment. State of Maharashtra versus Maruti Shripati Dubal, wherein the Honorable High Court struck down Section 309 of the IPC. This Bombay High Court judgment struck down Section 309 of the IPC. That provides punishment for an attempt to commit suicide by a person, and it declared it as unconstitutional. Now it opens a Pandora box everywhere. Now it was challenged before the Supreme Court in P. Rathinam versus Union of India in 1994. And the two judges bench of the Supreme Court took cognizance of the relationship. Section 309 IPC and Article 21. The court supported the decision of the High Court of Bombay of Maruti Shripati Dubal case and held that the right to life embodied under Article 21 includes right to die. Now, with this concept, again, Rathinam, was challenged before the Supreme Court in Gyankor versus State of Punjab in 1996, wherein again this question was brought before the Supreme Court, that what is the constitutionality of Section 309 and Article 21 of the Constitution of India. The question before the court was that if the principle of offence is an attempt, then the dictum of P. Rathinam can stand, and whether we can have a right to die. Now, the Supreme Court decided that there is no fundamental right to die. And overruled P. Rathinam in its entirety. Then again, there is a debate in the civil society. What will happen to all those people who are on deathbed? Whether they don't have the right? What will happen to them? How will they survive? There is no point in living such a life where you cannot live with dignity. Where is that dignity? You're on a deathbed, you're in a vegetative state. Aruna Bog again, Sean Bog is a it's one of the best case we can ever think of, we can ever see in a context. In 2018, this debate finally got an answer, and that was Common Cause versus Union of India, 2018. In this case, the substantial question of law before the Honorable Supreme Court was whether active euthanasia can be given or passive euthanasia. The Supreme Court decided that right to life includes a right to die with dignity. When the Supreme Court says so, the Supreme Court held that on the basis of the recommendations of the statutory committees, the Supreme Court gave certain guidelines for the committees to be constituted under the different constitutional bodies to look into the and medical bodies to look into the deliberations. And on the basis of that report, the Supreme Court held that the answer is passive euthanasia. Yes, all those who are in vegetative state, the medical opinion says so, that there is no possibility of revival. When that medical condition is accepted by the judicial authorities on the basis of medical criterions, then the notion of passive euthanasia can be read within the lines of Article 21 of the Constitution of India. So the domain of Article 21, expanded with the passage of time. It is not only this, that it is a right to die, but right to privacy. Putta Swami judgment, the Supreme Court opened a Pandora box. The Supreme Court made it clear that you need to understand that it is a very, very important right. You cannot by any means obstruct, or you cannot by any means destroy the peace and harmony of an individual by going into his domain or by affecting his peaceful enjoyment of his life. If it is, then it is direct violation of his right to privacy. So my dear friends, thank you very much. You have listened to me. I hope I'll again come to you and we'll discuss a number of good deliberations. I hope you will understand this. I have given the e-content from different sources to our website. It is available on the Lucknow University website, so you can check it. And thank you very much. Stay home, stay safe. Thank you.